Criminal Procedure Bar Exam Audio Review. Helix Bar Review Essay Recall Edition. Section 1. Fourth Amendment. A Fourth Amendment violation has four elements. 1. Conduct by government-authorized personnel. 2. A search or seizure occurred. 3. No valid warrant, or a valid warrant improperly executed. 4. No exception to the warrant requirement applies. Evidence obtained through a Fourth Amendment violation will be suppressed at trial. Search. Under Katz, a search has occurred if two conditions are met. 1. The person has a legitimate personal expectation of privacy in the area or communication. 2. That expectation is reasonable under the circumstances. Reasonable expectation of privacy exists in 6 places. Mnemonic. Hubcock. 1. Home, apartment, business, or hotel room. 2. Personal belongings, car, purse, wallet. 3. Private phone conversations. 4. Cell phone location data for 7 days or more. 5. Any items in which the person has an ownership interest. 6. Curtilage, front yard, backyard, or property intimately tied to the home. Curtilage is determined by 4 factors: proximity to the home, whether the area is enclosed, the nature of use, and steps taken to protect the area from observation. No reasonable expectation of privacy in 5 situations. 1. Information voluntarily disclosed to a third party or business. 2. Garbage or objects visually observable by the public. 3. Conversations overheard in public. 4. Open fields, unoccupied areas outside the curtilage. 5. Aerial surveillance of curtilage or open fields. No or EOP for 3 categories of people: prisoners, car passengers in any area of the car with exceptions for spouse, taxi service, or personal belongings, and guests in another person's home unless staying overnight. 2 exceptions where a search occurs even without a REOP. 1. Kilo. Police use technology not in general use to gather information about the home that would not otherwise be obtainable. 2. Constitutional trespass test. Police physically intruded onto a person's property beyond what was socially expected, with intent to gather information. Seizure. A seizure occurs if the police meaningfully interfere with a person's possessory interest in an item, or if a person reasonably believes they are not free to leave or terminate the encounter. Terry stop. The police officer uses physical force, or displays authority. The subject submits by stopping, and a reasonable person would not feel free to leave. Custody. An arrest by depriving freedom in a significant way must be supported by probable cause, a fair probability under the totality of the circumstances that evidence of a crime will be found, or that the person committed a crime. Obtaining a valid warrant. For requirements: 1. Probable cause, fair probability that evidence of a crime will be found, or the person committed a crime. 2. Neutral and detached magistrate, no interest in the outcome. 3. Officer must sign an affidavit under oath. 4. Warrant must describe with particularity the place to be searched, items to be seized, individuals to be arrested, or conversations to be overheard. Executing a valid warrant. If officers exceed the scope of the warrant, an exception must apply. Knock and announce rule. Officers must knock, announce they have a warrant, and give a reasonable time to respond, unless they reasonably believe it would be ineffective or inhibit the investigation. 13 exceptions to the warrant requirement. 1. Exigent circumstances. Imminent danger, evidence about to be destroyed, imminent escape. Hot pursuit. Requires probable cause. 2. Plain view. Lawfully present. Seize item in plain view. Probable cause it is contraband or evidence, and lawful right of access. Plain feel. Lawful pat down plus immediate recognition of weapon or contraband. 3. Lawful arrest. Probable cause for felony arrest outside the home. Misdemeanor arrest without warrant only if committed in the officer's presence. 4. Search incident to lawful arrest. Upon lawful arrest, officer may search the person and area within immediate reach, administer a breath test, take DNA for serious offenses, conduct a protective sweep of enclosed spaces if arrest is in a home, search the interior of a car but not the trunk, and search the exterior of a cell phone, but not digital data. 5. Automobile exception. Probable cause to believe contraband or evidence in the vehicle, including the trunk. Exceptions: car parked in curtilage for some time, or probable cause only as to a specific container. 6. Consent. Owner or someone with authority or apparent authority consents freely and voluntarily, can be revoked at any time. Third-party consent covers common areas, but not another tenant's room unless a parent of a minor. If the other person is present in objects, no consent. 7. Terry stop and frisk. Reasonable suspicion of criminal activity for the stop. Reasonable suspicion that the suspect is armed and dangerous for the frisk. Limited in time and place. Car interior may be searched with reasonable suspicion. The driver has a weapon. Trunk requires probable cause. 8. Special needs searches. DUI checkpoints, airport screenings, metal detectors. No probable cause or reasonable suspicion needed if for non-criminal purpose, not too invasive, data supports effectiveness, and criteria for stopping are clearly identified. 9. Border search. Routine searches require no probable cause. Non-routine invasive searches require reasonable suspicion. 10. Government search. Reasonable work-related searches of employee desks, cabinets, office, and equipment must be non-investigatory or based on reasonable suspicion of work-related misconduct. 11. K-1-2 public school. Reasonable grounds to believe the search will lead to evidence of law or school rule violation. 12. Inventory searches of lawfully impounded property. No warrant needed. 13. Administrative searches of closely regulated business industries. Exclusionary rule. Fruit of the poisonous tree. Evidence obtained through an unconstitutional search or seizure, and any later evidence, that would not have been discovered but for the illegality, is excluded from trial. 5 exceptions. Mnemonic, AG. 1. Independent source. Police later obtained the evidence independently through untainted activities. 2. Inevitable discovery. Police would have eventually discovered it by untainted means. 3. Dissipation of taint. Courts look at 4 factors: length of time between illegality and seizure, purpose and flagrancy of the initial unlawful conduct, existence of intervening causes, and whether the defendant acted with free will. 4. Good faith. Police acted in good faith relying on a warrant, binding judicial precedent, or an isolated bookkeeping error. 5. In-court identification. Not excluded based on a prior illegal search or seizure. The Fourth Amendment protects against unreasonable searches and seizures. Identify whether a search or seizure occurred, whether a warrant was required, whether an exception applies, and whether the exclusionary rule bars admission of the evidence. Section 2. Fifth Amendment and Miranda. A Fifth Amendment violation has 2 elements. 1. The evidence is a testimonial statement made to government personnel. 2. The statement was coerced. A Miranda violation has 2 elements. 1. The defendant was subjected to custodial interrogation. 2. Miranda rights were never read, or were invoked but questioning continued. Testimonial statements include oral and written communications that explicitly or implicitly convey factual information. Non-testimonial includes fingerprints, blood samples, voice exemplars, handwriting samples, and tax documents. Coerced confession. Courts examine the totality of the circumstances using 2 factors. 1. Physical or psychological pressure. 2. The defendant's specific characteristics and known vulnerabilities. Physical force or threats make the confession per Southeast involuntary. Basic deception, leading questions, and vague promises of leniency alone are not coercive. Miranda rights apply when 3 conditions are met. 1. The suspect is in custody. 2. The suspect is subject to interrogation. 3. No public safety exception applies. Custody. A person is in custody if a reasonable person would not feel able to terminate the interrogation and leave, and the environment has the same inherently coercive pressures as a police station. Interrogation. Express questions or words or actions the officer should know are reasonably likely to elicit an incriminating response. Voluntary statements and routine booking questions are not interrogations. Public safety exception. Miranda is not required when questioning relates to an immediate public safety issue. For Miranda warnings, right to remain silent, anything said can and will be used against the suspect at trial. Right to counsel during questioning, and if indigent, counsel will be provided. Invoking or waiving Miranda. Waiver must be knowing and voluntary. An uncoerced statement after Miranda warnings are understood establishes an implied waiver. Invocation of right to counsel must be unambiguous and unequivocal. Questioning must stop until counsel is provided and physically present. Police may reinitiate after 14 days and new Miranda warnings. Invocation of right to remain silent must be unambiguous and unequivocal. Merely staying silent is not enough. Police may reinitiate only after honoring the invocation. Courts look at time between interrogations, whether a different crime is involved, and whether new warnings were read. Voluntary reinitiation. A suspect may reinitiate conversation with police at any time. To determine whether a Miranda violation occurred, analyze whether the suspect was in custody, whether interrogation occurred, whether Miranda warnings were given, and whether the suspect validly invoked or waived those rights. Section 3. Sixth Amendment. The Sixth Amendment right to counsel attaches once formal proceedings have commenced, such as indictment or arraignment. 2 protections attach. 1. The suspect must be represented by counsel at every critical stage of the prosecution. 2. The police and prosecutor cannot interrogate the defendant without a lawyer present. Critical stages include lineups, interrogations, plea bargaining, preliminary hearings, trials, sentencing, and the first level of appeal. Does not apply to photo arrays, fingerprint matching, or voice identifications. The Sixth Amendment is offense-specific. It applies to interrogations about the charged crime. Police may still interrogate about separate crimes. Effective assistance of counsel requires the attorney was deficient based on an objective standard of reasonableness and the defendant suffered prejudice as a result. Suspect identification. Lineups and show-ups must be fair under the totality of the circumstances. 5 factors. 1. The witness' opportunity to view the perpetrator at the time of the crime. 2. The witness' degree of attention. 3. How well the prior description matches the defendant. 4. The witness' level of certainty at identification. 5. The length of time between the crime and the identification. The right to counsel attaches to lineups and show-ups once formal proceedings have commenced. Counsel must be present or the identification will be excluded. Photo identification must be fair and cannot be unnecessarily suggestive or create a considerable risk of mistaken identification. The Sixth Amendment right to counsel attaches upon commencement of formal proceedings and applies to all critical stages. Analyze whether the stage at issue qualifies, whether counsel was present, and whether any identification procedure was unduly suggestive. Section 4. Fair trial. A defendant has 7 fair trial rights. Mnemonic, GESIP. 1. Jury trial with at least 6 jurors from a fair cross-section of the community, required when the charge carries more than 6 months imprisonment. 2. Impartial judge. No close personal or financial involvement. 3. Speedy and public trial. 4. Effective counsel. 5. Introduce exculpatory evidence. 6. Confront witnesses. Cross-examination. 7. Proper prosecutorial conduct. No perjury or vindictiveness. Jury trial. All verdicts must be unanimous. Fair cross-section violation requires a distinctive group, underrepresented in the jury venire, due to systematic exclusion. Jurors may be challenged for cause, unlimited, or by peremptory challenge. Peremptory challenges cannot be exercised based on race or gender. If challenged, the prosecutor must provide a neutral explanation. Competency to stand trial. The defendant must understand the nature and significance of the trial proceedings and be able to assist in the preparation of the defense. Mental state is analyzed at the time of trial, not the time of the crime. Section 5. Guilty pleas. A guilty plea must be made voluntarily, knowingly, and intelligently. Failure to satisfy these conditions allows the defendant to withdraw the plea. Voluntarily means without coercion. Knowingly and intelligently means the defendant is fully aware of the charges and consequences. Section 6. Double jeopardy. Individuals are protected against a second prosecution for the same offense after an acquittal or conviction. Double jeopardy does not bar a subsequent civil case. Jeopardy attaches after the first witness is sworn in a bench trial, or after the entire jury is impaneled and sworn in a jury trial. Same offense test. If an element in each offense is different, double jeopardy does not apply. If convicted of the greater offense, prosecution for the lesser included offense is barred. Different sovereigns, federal and state, are not barred from both prosecuting even for the same conduct. Section 7. Cruel and unusual punishment. The Eighth Amendment prevents cruel and unusual punishment. 3 factors. 1. Nature of the crime. 2. Severity of the penalty. 3. Sentences of similarly situated defendants. Capital punishment is disproportionate for most crimes other than homicide. Persons under 18 at the time of the crime may not be executed or sentenced to life without parole for non-homicide crimes. Section 8. Burden of proof. Due process requires a presumption of innocence. The government must prove all elements beyond a reasonable doubt, a very high standard requiring certainty or firmness. Affirmative defenses. The defendant bears the burden of production and proof by a preponderance of the evidence. If the defendant raises a plausible basis, the government must disprove beyond a reasonable doubt. Section 9. Appeal and error. Harmless error. An appellate court will not reverse unless there was a substantial risk the error affected the outcome. 5 structural errors require automatic reversal. Denial of counsel at trial, denial of a public trial, constitutional violations in jury selection, constitutionally deficient reasonable doubt instructions, and a biased trial judge. Sufficiency of the evidence. Conviction affirmed if a reasonable juror could have found all required elements beyond a reasonable doubt. Viewing evidence in the light most favorable to the prosecution. Clearly erroneous. Reviewing court will not reverse unless the decision is unsupported by substantial, credible evidence. Habeas corpus. A convicted inmate may challenge the lawfulness of detention on jurisdictional or constitutional grounds. Does not address guilt or innocence. 1-year statute of limitations. Successive filings prohibited. Exhaustion of remedies required. End of criminal procedure review. Repeat from the beginning.